Well, sometimes the Fifth Circuit Court of Appeals, that right-wing appellate court, the rightest of right wing, sometimes they do surprise us. It also depends on which three judges are being asked or heard whether Louisiana's law to shove down the throats of all students from kindergarten until they graduate from high school, a copy in each and every classroom of the 10 Commandments, Protestant style version, by the way, in 11 by 14 papers. Even the Fifth Circuit Court of Appeals in their new ruling found that this violated the Establishment Clause of the First Amendment, which is the bedrock that separates church from state. It's the wall between church and state. It's under attack at the United States Supreme Court, but there are two Supreme Court precedents right on point about the display of the 10 Commandments, both in classrooms and otherwise in public spaces. And those two Supreme Court cases haven't yet been overturned. So the Fifth Circuit cited them, struck down the Louisiana law, and now we're off and running, I'm sure, to the United States Supreme Court. The Fifth Circuit Court of Appeals, 3-judge panel, Judge Dennis, 89 years old, the revenge of the senior status judges, as I've said before, a Clinton appointee. Judge Haynes, a George W. Bush appointee, and Judge Ramirez, who wrote the opinion for the court, an Obama appointee. I'm going to dive into it right now because it matters here on Legal AF. Take a moment, hit the subscribe button, help us continue to grow this base, this movement that we're doing here. How did we get here? Well, Louisiana, along with some other states like Texas, South Carolina, and Utah, all tried right after a Supreme Court decision a couple of years ago we call Kennedy versus Bremerton, in which the Supreme Court did side with a high school football coach that wanted to hold a prayer session at midfield during football games. And they said, well, we don't see that as a violation of the Establishment Clause, which prohibits the government being in the business of establishing religions. There's the free exercise clause of the First Amendment. You and I have the right to freely exercise our religion or no religion at all. And the Establishment Clause. Government is out of the business of establishing religions, what it sounds like. Kennedy versus Bremerton seemed to breathe new life into these various right-wing states, MAGA states. Like, well, if a football coach can pray on public school property, let's put the 10 Commandments in every classroom. I mean, the leap is considerable there, the logical leap, the jurisprudential leap, but, they tried. And so they filed their case. Unfortunately for them, there are two cases on the books from the United States Supreme Court. One is directly on point. Stone versus Graham said that a Kentucky mandated 10 Commandments display violated the Establishment Clause. That's U.S. Supreme Court precedent that's never been overturned. Similarly, there's another case called Van Orden versus Perry, also United States Supreme Court, that said similarly, you can't have like a public display with taxpayer dollars in a public park of the 10 Commandments. Now, there's been a lot of other murky case law that's come up, making this area not as bright line as it should be. You can run a flag up a flagpole if there's a lot of other flags up that flagpole. Things, you can have a religious Jesus crash nativity scene as long as you have a giant menorah next to it. We've all seen it in our public squares in various communities, big and small, around America. But as soon as the Louisiana governor signed HB 71 in Louisiana to establish a mandate that this Protestant, their words, version of the 10 Commandments, not even the Jewish version, and 11 by 14 in each and every classroom, now you're shoving religion down people's throats, Because I thought Republicans were all about letting the family unit be guided by parents. They don't want puppy books about the LGBTQ plus community in their libraries. They don't want values to be taught by schools, in public schools or by teachers. They want it all to be done at home. Then why are we shoving the 10 Commandments down everybody's throat when some people, that's not their commandments? I'm not saying that other religions don't respect criminal code, but that's a moral declaration of things. That's a religious declaration of things. And we don't, as of yet, live in a theocracy. So we get the ruling. Let me read to you a couple of interesting things they had to square away before they got to the heart of the case. One was, did the group that brought the case, including a reverend. The case is Reverend Darcy Rowick on behalf of themselves and a whole bunch of other people. They're religious, but they don't think Protestant Ten Commandments should be violating the separation of church and state. So I give them a lot of credit for that. First thing they had to square away was, do these parties have standing? Do they have an injury by these postings or not? And here's what the court had to say about that, establishing they do have an injury in fact, in order to have the standing necessary to prosecute this case on someone's behalf. Plaintiffs allege, on page 21, plaintiffs allege more than offense alone. As noted, if HB 71 goes into effect, because it's been blocked, students will be subjected to unwelcome displays of the Ten Commandments for the entirety of their public school education. There is no opt-out option. Plaintiffs are not mere bystanders who have failed to identify any personal injury, nor are plaintiffs asking the courts to redress generalized grievances. They allege that students will be pressured to observe, meditate on, venerate, and follow this scripture, and to suppress expression of their own religious beliefs and backgrounds at school. That gives them the injury. Now we move on to kind of the heart of the matter, starting on page 27 through 29 of the order, which I will post on Legal AF Substack. The Establishment Clause on page 27, they properly recite, citing case law going back to 1947, the Everson case. The Establishment Clause was intended to erect a wall of separation between church and state. Sure, it's been under attack. Sure, it's in shreds. There's very little left of it. It's almost in rubble based on the Supreme Court's right-wing, MAGA right-wing majority over the years, including recently. But, it still exists. And it's supposed to be one of the foundations of our Constitution. The protections afforded to school children by the Establishment Clause unquestionably implicates basic constitutional values. They quote a Supreme Court case on that. Families entrust, this is from a Supreme Court case, families entrust public schools with the education of their children, but condition their trust on the understanding that the classroom will not purposely be used to advance religious views that may conflict with the private beliefs of the student and his or her family. Students in such institutions are impressionable, and their attendance is involuntary. The state exerts great authority and coercive power through mandatory attendance. The public school is at once the symbol of our democracy and the most pervasive means for promoting our common destiny. In no activity of the state is it more vital to keep out divisive forces than in its schools, citing the Edwards case. Then they go over there's two main cases in this area at the United States Supreme Court. Stone versus Graham from 1980, in which the Supreme Court struck down a Kentucky statute requiring that the Ten Commandments be displayed on the wall of every public classroom because it has no role it has no secular purpose. Now, the Louisiana tried to argue, and it was quickly shot down by the appellate court, that they had a secular legislative purpose, that it's clear, it's Western civilization and the common law of the United States, and it's a teachable moment. And the three-member panel of the Fifth Circuit said, yeah, that's a sham. That's a sham for religious inculcation and veneration being shoved down students' throats, and we're not going to accept it. They then went on page 29 of the order, the three-judge panel, unanimous, to say that we then go from Stone to the Supreme Court case in Van Orden versus Perry in 2005 that similarly said that a monument of the Ten Commandments displayed on the Texas state capitol grounds was not constitutional under the Establishment Clause. Well, actually, there they allowed that on the state capitol grounds. However, the Supreme Court noted that there are, of course, limits to the display of religious messages or symbols. Far more passive use of the Ten Commandments than was the case in Stone. The display is not on the grounds of a public school. In other words, they allowed the Ten Commandments to be displayed on the Texas grounds of the state capitol, but that same item displayed in a school because of the compulsory aspect of it, because of the mandatory aspect of it, the impressionable minds aspect of it, would run afoul of the Van Orden versus Perry analysis. That's the better way to put it when you put Stone and Van Orden together. Now, what's going to happen now that this has been blocked by the Fifth Circuit Court of Appeals. Because Stone, the case about Kentucky's same use of the Ten Commandments, is still good law. It therefore strikes down HB 71, the law. In fact, they end it this way: Stone still stands, HB 71 fails. Can't think of any more pithy and succinct end to a appellate case than that. What's going to happen now? Well, we know. The case is going to get up to the United States Supreme Court. I don't know about an emergency application. It could be led by Louisiana. A bunch of other states that support Louisiana and are red, like Texas, South Carolina, and Utah, will join in with amicus briefs, and they will get it to the United States Supreme Court. It won't be an emergency application situation, I don't believe. It'll be something that they may take up in the new term, which starts the first Monday in October. They're going on summer hiatus now, subject to emergency applications that will be no doubt filed by somebody involved with the Trump administration. So I think it gets up there. And then we're going to have to see. We got 6 who are very religious and believe in religion in the public square. Amy Coney Barrett, first among them. Can't trust her on anything related to religion. They've already sided with the praying football coach, the flags going up the flagpole, the taxpayer dollars being used for resurfacing religious school playgrounds, other arguments related to religious schools and their entitlement to public funds. Let's remember, they almost in Kentucky just ruled, except they were tied 4-4 because Amy Coney Barrett had to step off for a conflict. They were almost about to rule this close that taxpayer dollars could be used for religious charter schools. So you see where this court is mentally. 10 commandments in everybody's face from 5 years old till 18 or 17 in classrooms. I think that's a bridge too far, but they'd have to overturn precedent. But the Supreme Court likes to overturn precedent. So we'll continue to follow it right here. I told you what should happen, what could happen, and then I will tell you what will happen, what has happened here on Legal AF. So until my next report, take a moment, hit the free subscribe button. I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.